actually registered. Sorry. Oh, that's okay. That's those are actually protected by the U.S. Copyright Office. So it's a sister agency to us. It's not ours specifically. We're not the ones granting the rights, but we do talk about it because it is part of the entire intellectual property ecosystem. So within the USPTO, we have about 14,000 employees. The lion's share of our employee base are patent examiners. And each of our patent examiners are specializing in a certain technology subject matter area. And so some patent examiners will only review antenna patents. Some of them will review battery patents. And so each of them are specialized in a certain area. So 80% of our workforce do have a technology background. They are specialized in a very special area because it's needed in order for them to review patents. Another big part of our agency is what we call trademarks, and I'll go a little bit more detail into that. But anyone actually who has a business has a trademark. A trademark's a source identifier. It tells you who is providing the goods or services. So if you have a name for your business, a logo for your business, or a product that you are providing or service you are providing, then you have a trademark. And what you would do is that if you would like nationwide protection, you would come to my office to be able to register that trademark. And so we have a big group of people who are reviewing those trademarks at the end of the day. We get about 660,000 patent applications every year, as well as about close to 770,000 trademark applications. And those numbers actually increase year after year. And so here is a landscape of all the regional offices that we have around the country. We are headquartered in Alexandria, Virginia, and then we have regional offices around the country. My office is located in downtown Dallas, but we also have offices in Silicon Valley, in Denver, as well as Detroit. And we've also started to open up what we call community outreach offices. So our first community outreach office is actually in New Hampshire. Each of these offices, except for the community outreach office, each of these offices have quite a few employees. And so we have patent examiners, trademark examiners, and judges that are sitting within all of those offices. Now, the community outreach office, it's a subset, so it's really just a one-person office. And so they're designed to just be there to be a resource for the community. And so they're not really there for employees to sit in. And so each of the regional offices are set up very similarly from a resource standpoint. We do have folks that you can come and talk to and ask questions in person or virtually. And so you can also come and meet with patent examiners. And so if you have cases that you have before our office and you want them to be reviewed, you could do that. You can also, if you get to the point in which you are appealing a decision from a patent examiner or a trademark examining attorney, you can argue your case in person in our office as well. But we also have a number of different programs that are very similar to this that we will host in person at our office as well. If you want to visit our office or you want more information about it, please feel free to reach out online at uspto.gov and you can find out more information about our office. Okay, so now I'm going to jump into the substance of our particular program. And so when you think about intellectual property, think about the two words individually. So intellectual is something that you've created in your mind, you've developed in your mind, and now you have transformed it into a property right. Now, I know that there are a number of real estate folks who are in the real estate business that are here, and someone who just got her license. Mm-hmm. And so if you think about intellectual property, and what you could do with it, it's the same thing that you can do with a house or with a car or any other property that you get. You can sell it, you can rent it out, and in intellectual property terms, that is called licensing, right? You can give it away. You can give it to your spouse, your kids, your friends. Anything that you can do with a house or a car or anything that you own is the same thing that you can do with intellectual property. The difference is that intellectual property is what we call intangible property. It's not something that you can touch and feel, right? So real estate is considered real property, right? A car, your computer, the tables, the desks, they're all tangible property. So these are all assets, and they're an asset as part of your business. So when you think about intellectual property, think about it as something that property that you own, an asset you own that is part of your business. So let's take a broad overview and an example of a mobile phone. And a mobile phone is really nice to think about because there's a number of different intellectual property types that are within a single mobile phone. So patents are inventions, right? They are something that you've created. And so an example of a patent that is within a mobile phone is a camera, your battery, your screens, antennas, data processing method, or semiconductor circuits. Those are someone's invented it. And there are actually thousands of patented products that are embodied within a single phone. Another type of patent is what we call a design patent. It's the look and feel of a product. And so it can be the curve or the shape of the bezel or the phone. It could be the screens, or it could even be the home button itself. Cars often have a lot of design patents that are protecting them because of the grille and then the shape of the car. Those are things that a lot of car companies are actually protecting on the car itself. Trademarks, as I mentioned earlier, is a source identifier. It tells you who is providing the goods or services. In this particular case, this phone is made by Samsung. And this particular phone is called a Galaxy Note. So when you see the name Samsung or you see the name Galaxy Note, you know who is providing that particular product. What you also know is the level of quality of that product that is associated with what they are actually making. So trademark, source identifier. Copyright. Copyright is something that is an original work that is embodied in what we call a tangible medium. So a copyright is artistic. There has to be an artistic component associated with it, a creative component associated with it. And then it's embodied in what we call a tangible medium. Tangible medium in this case, like for software code. Software code is created by something. It's an original work, but it's saved into a hard drive or a memory device or a chip. So that's the tangible medium, right? And instruction manual. If it's a hard copy of the instruction manual, the tangible medium is the piece of paper that it's printed on. So a copyright exists once it is printed onto that piece of paper. So ringtones, same thing, saved into a hard drive, memory device, or something else. That's when the copyright exists. Trade secret. Why do you think that there's a bunch of question marks on trade secret?
This is a secret.
There you go. That's right. Okay. We know that there are trade secrets in here. Right? We just don't know exactly what they are. It's likely, at least at a minimum, some of the software code or the processing methods, but there are trade secrets that are in here, and we just don't know exactly what they are. Okay. All right, I'm going to launch into each of the buckets of intellectual property in a little bit more detail right now. But before I do that, is there any quick questions? Okay, yes, ma'am.
So if you were going to make an application, do you have to do so at your local office?
No. So if you were going to file something, you could do it all online. You would just create an account with our office and then you would do it online. We very rarely get mail-in applications anymore. It does happen, but even if you are going to be mailing in an application, you would mail it into our headquarters and you're not going to be mailing it into our local office. All right, so let's talk a little bit more about patents. There's a couple of different types of patents. The primary one that most people think about is what we call a utility patent. The utility patent is the widgets that are created, the processes that you have come up with, and you actually get a monopoly of that invention for a short period of time with our office. So once you get a patent, you have 20 years. That's the monopoly that you get from the filing date of the actual application that you send in for our office. But what do you get for that? A patent is what we call an exclusionary right. It doesn't give you the right to do something, but it prevents others from doing something without your permission. And specifically, what does someone have to get your permission for? They have to get it to make, to use, to sell, or to offer to sell, or to import that product into the United States. Patents are jurisdictional. Actually, all intellectual property is jurisdictional. And what that means is that if you apply for a patent with our office, then it's good within the United States and our territory. If you want to get protection in another country, you'll have to go to that particular country to be able to get that protection as well and file an application with that particular country. But if you file within the United States, you'll be filing with my office and you'll get the protection within our office. And then if someone wants to practice, as they call it, your patented invention, then they'll have to come and get permission from you to do it. Okay. So with that, so what types of things are actually protected? There are four different buckets. It's called a process, machine, article, manufacturer, and composition of matter. So if you look on your screen right here, this is an example of a patent or a figure from a patent by Abraham Lincoln. Abraham Lincoln is the only president who is an inventor and who owns a patent. And what he invented was actually a buoying system, a way to make vessels, large vessels, float. And so in this patent, it is what we would call a machine, right? It is the actual device that he has developed to allow for the ship to actually float. And so that is what is protected. But what could also be protected with that is the method of making that particular device in order for it to float. It could also be the assembly or the manufacturing process that is associated with it. Or if that device was made out of plastic or metal, it is the actual equipment or the molding machine that is associated with it that could also be protected with respect to a particular patent. So those are different things that can be patented if you do submit an application. Design patents, look and feel. In this particular case, what you see here is a root beer bottle, right? The root beer bottle, the shape, the clover at the bottom, the shape is actually what is protected. And that is actually protected 15 years after we approve that particular patent. So that's what we call a grant. Plant patents. Plant patents are anything that have some sort of human intervention, and it is something that you can actually patent. You can't patent something that is naturally growing, right? So you can't go out and get a leaf from a tree or a blade of grass, submit it to our office and say, hey, I invented something new, right? There has to be some sort of human intervention, and that's typically genetic alteration to that particular patent or to that plant. It's good for 20 years, and as you can see, the example that we have here is a poinsettia. So as I mentioned, most patents, right, are good for 20 years from when you file. The only exception is actually the design patent. And so in order to get a patent, you have to file what we call a non-provisional application. But a lot of people, especially small businesses and entrepreneurs, they will file what we call a provisional application. So the reason that people do this is that in order to get an application or in order to get a patent, it's a race to the patent office. So whoever files the application first with our office is the one who gets to secure the right to it. And so timing is really, really important. And so a lot of times, sometimes people will file what we call a provisional application so that they can get their place in line. They could reserve their place in line. And so there are a couple of strategic reasons why folks might consider a provisional application. One is it's not as complicated as a non-provisional application. And as a result, the cost is not as high in order for you to file it. And you also get what we call the patent pending status, which is really a benefit. The other thing is that sometimes, as an inventor or a new business owner, you may not know if your idea is going to take off yet, right? And so you don't want to invest all of that money into a full-blown patent until you know that this is the right idea that you're going to move off with. You may be able to find some folks who are interested in licensing or helping to support. The other thing is that you might be going and doing a number of pitch competitions, right, to try to figure out if you could secure funding. So because you get the patent pending status, it increases the likelihood of you getting funding. We've had statistics that it's up to 70% increased likelihood that you're going to get that funding. And so you could do that, get your protection, because not everyone's going to sign that dotted line on a non-compete, or that they're going to kind of keep this a secret, right, or take it from you. And so because you have already filed it with the office, a provisional application is a good step for you to consider as you're going through this process. Now, the thing is, you have to convert that provisional application to a non-provisional application within a year in order for you to keep the date or secure the date that you originally filed the provisional application. Right? All right. Let me take a quick pause on any of this to see if there are any questions.
We also do them at the end and we go between online and in person.
All right, then we could do that. Let's move forward then. Okay, trade secrets. Okay, so a trade secret is anything that you keep secret and there's an economic value that is associated with keeping it secret. And so we've talked about a couple of examples, right, already on what a trade secret is. The Kentucky Fried Chicken, right, the secret herb that they have, or spice, I think that's what they call it. Krispy Kreme donuts, the glazed donuts, they actually have a secret ingredient that's associated with it. Same thing with Coca-Cola. Some of you may actually ask, well, you know, if you look at the back of a Coca-Cola can or a bottle, you see the list of ingredients that's actually there. Well, that's actually not what is secret, right? What is secret is the actual process of making it. We don't know exactly how much sugar is in there, how much water. We don't know at what point in time they put in the carbon dioxide to make the bubbles, right? Or how they mix it, what speed or temperature. All of those things are actually a secret, and that's information we don't know. And Coca-Cola has been able to maintain that secret. And so they've been able to have a competitive commercial advantage associated with that. Same thing with Google. We don't exactly know what the algorithm or the code that is supporting the Google code when you do a search and what comes up first, second, third, or even on the next page or last. We don't know exactly how Google selects that. And so that's a trade secret that they've been able to maintain and that they haven't shared, right? When you think about trade secrets and when you think about patents, they're actually what we call polar opposites. And so many businesses, as they're trying to figure out whether they're going to file a patent or they're going to try to maintain it as a trade secret, they're trying to look at these two things. Patents is a public disclosure. right? You're sharing with everyone how to make this. You're sharing your invention, and in exchange, you get a monopoly for a short period of time. Trade secrets, they are kept secret as long as they're kept secret, right? Once the secret is out, it's out. There's no bringing it back. But you can keep a trade secret forever if you want to. But you actually need to, as a business owner, proactively take steps in order to maintain that secret, whether it's by contract, right, in which people, your employees are agreeing to sign to keep these secret, or you are physically locking something up. The Coca-Cola formula supposedly is split in half, put into two separate safes, and there's two people who know the combination of the safes, but they don't know, only one per safe, and they don't know each other's combination. Supposedly that's what it is. So they've taken that proactive step in order to be able to keep it safe. If something is easy to reverse engineer, right? Easy for someone to figure out without coming over and stealing the information from you, then it's probably not something that you want to keep as a trade secret. You may want to patent it, because if someone figures out themselves how to reverse engineer something, then they have a legitimate right to be able to use it, and they can go ahead and move forward with it. Companies like Coca-Cola, Kentucky Fried Chicken, people have not been able to figure out the secret recipe by reverse engineering. And so they've been able to keep their competitive edge and be able to move forward. People have tried, but they have been unsuccessful at keeping that. So a couple things to think about as you are looking at those two different buckets. Okay, trademarks. So a trademark is a source identifier. It tells you who or what company is providing that particular goods or services. Now, a service mark is a subset of a trademark. It's specifically for companies that provide services, but it essentially is a trademark at the end of the day. So let's talk about what things can be trademarked. So the typical trademark are actually a word, or what we call a design. Many people think of it as a logo at the end of the day. And so you can have a word like Starbucks, or you can have the siren. I used to call it a mermaid, but I was corrected by Starbucks that it's actually a siren. If you see that logo of a siren, then you know it's associated with Starbucks. Same thing, right? Nike, the most well-known trademark around the world. The swoosh symbol. What is the slogan associated with Just do it. All right. Yeah, see, very well known. That's also a trademark. Target, either the word or the actual bullseye. What you know from these trademarks is not only the name, but you also know what the good or service is that you are going to be getting from this particular company when you see this. And so, yes, ma'am.
I'm just curious, why does the Starbucks one have the TM and the other two do not?
That's a great question. So a TM indicates trademark, right? And so some companies like Starbucks, they can add it, or you don't actually have to add it. So a TM, once you get, you have your name of your company or the product that you're going to be providing, you can automatically put people on notice that you have a trademark, right? But the TM, you can start adding this once you start selling your product or using it in the marketplace. All right. So you don't actually have to register it with us. Once you do register it with the USPTO and we accept your registration, then a lot of times, or then you'll be able to use the circle R, as we call it, right? And so you'll see that on some symbols. But you can only use the circle R if you have a registered trademark with our office. Now, why do you want to register if you already can start using it once you are in business, right? one thing is that if you register with our office, you get what we call nationwide protection. Okay, so once you do that, you automatically get the nationwide protection. You can also register state by state. Every state has a system in order for you to register. So if you have a business that is very local and you're not planning on expanding outside of Texas, for example, then you could go to the Secretary of State and you can register for a trademark through the Secretary of State. It's not as expensive. And a lot of family-owned businesses, they decide that that is what they want to do and they only want to register. But if you want to go outside of Texas and you think that you're going to go into multiple states, you'll have customers across the board, then you'll want to consider nationwide protection and apply for office. Now, you don't actually have to register, right? As I mentioned. And you can go on what we call common law rights. But the difficulty with common law rights is that it is jurisdictional and it is limited and it is a court determined jurisdiction. So for example, let's say that I opened up Hope's Dry Cleaning here in the Denton area and someone else opens up Hope's Dry Cleaning in Houston, right? So the question is going to come about as how big is my trademark region, right, that is being protected? If is it within Denton? Is it DFW? Is it all of North Texas, right? And then there's this competitor that is in Houston. What can I stop them from using that Hope's Dry Cleaning? Is it just in Houston or is it all of South Texas? We don't know, right? And so it's really going to be a court determination on where your customers are, how big it is, how much you've been marketing, all of these questions that are out there. And so in order to get that guarantee of protection over a certain state or across the country, it's a really good idea for you to actually register it. Okay. Okay. All right. Let me move forward. I'm watching the time. Sorry. So I just want to make sure. Okay. There are a couple other types of trademarks that you can get. You can get what we call a color mark, right? So a color mark is a specific color. All right. So that box on the left, who knows what that is? Tiffany's. All right. And what are you going to get from Tiffany's? Jewelry. All right. And so it's a source identifier and it's associated with jewelry as the goods that you're going to get. UPS Brown, you can see this on all of their packaging, on the trucks, the uniforms, right? That's the color of it. John Deere, same thing, the green with the gold, right? You know where you're going to get when you see that particular symbol or see that particular color that is painted all over the John Deere equipment. Scents, the smell. All right, who can smell Play-Doh? All right, a very distinct smell, right? And so everyone knows what it is. So that's a trademark. You can also buy this liquid power groovy grape. Actually, it's a lubricant that you can put in your car in case you want your car to smell good as you're driving around. This is an option for you. It is a scent and is protected by a trademark. Sounds, right? The Darth Vader breathing, the lightsaber, the sound when they're fighting or they're swinging around the lightsaber. Buc-ee's actually recently applied for a trademark. So if you ever go to your next Buc-ee's, listen when they're actually preparing the brisket and then they yell brisket on the board. That is the sounds that they recently applied for and that they received a trademark for. NBC, the NBC chimes, right? ESPN as well, actually as well. Those are all sound marks, things that you associate with a particular company and what goods or services that they provide. Trade dress. This can be shapes like the Hershey Kiss, right? Whether you see it in the wrapper or outside the wrapper, whether you see the name of the little flag with it, we know that it's a piece of chocolate made by Hershey's and it's called a Kiss. Doc Marten boots, right? The laces, not the laces, the stitching, the yellow stitching around the bottom. The Apple Store, Whether you see the Apple symbol or not, when you look at that, you can see that that is the Apple store. And then the Coca-Cola bottle, right? The Coca-Cola bottle, we talked about the design patent, right? Even though that was a root beer bottle, still owned by Coca-Cola, but you know who is providing the goods or services by the shape of that bottle. Same thing here with the Coca-Cola bottle. Okay, last bucket is copyright. So copyright is original work that has to have some sort of artistic component that is embodied in a tangible medium. And so we talked a little bit about software earlier. That is something that could be protected by copyright. But what you see here are the more traditional areas of protection for copyright. A song, whether it's an MP3 player, do people still have MP3 players? But anyways, an MP3 player, and it's saved on there. Books, right, that are in printed or soft copy, movies or sculptures. All of these have some sort of original work. There's an artistic component to it embodied in a tangible medium. Now, as I mentioned, copyrights are actually, you register a copyright with the US Copyright Office. Similar to trademarks, copyrights exist right when you have that artistic work embodied in that tangible medium. That's when it arises. So you don't actually have to register it in order for you to have that protection. But there are benefits, specifically with copyrights. The benefit that's associated with that is the protections that you may be able to get to prevent others from copying your work. In order for you to sue, right, or if you have to go to litigation to stop someone from using your copyright, you need to have a copyright registration in order to do that. If you want to use the arm of Customs and Border Patrol to prevent things from shipping into the United States of your copyrighted work, then you need to have that copyright registration. So there are a couple of different benefits associated with that. And it puts people on notice that you do own this particular copyright and it is registered as well. Here's some other examples of different types of copyrights. Okay, so here's just a basic summary of everything that I've talked about today. I know that this presentation is going to be sent out to you. Additionally, for those of you who are in the room, you do have a summary of the different types of intellectual property that you could bring home with you. I know that that's something that I'll send a soft copy to Tracy and to Lourdes, and they will send that out to you after this particular program. All right. Okay. Let me jump into resources real quick, and then we could do questions after that. So all of the information that I am about to let you know is on our website. So you can go to www.uspto.gov. You can also sign up for email alerts as well. We have an inventor newsletter that features our different inventors and their success stories that you can sign up for. We also have a web page for startup resources. And so this is a great place for you to start and to get more information on anything that I'm talking about. Or if you want to take some of our deeper dive and our deeper classes that we have, this is a great place for you to go and look up that information. Path to a Patent is an 8-part series. It's free, and we give it 4 times a year. And the classes will take you from beginning to end if you want to go and file a patent application by yourself. This is a great resource for you. It's the same day, once a week, every week, and it's a virtual class. And so you can take this from home if you are interested in it. We do have a 1-800 number for inventors, and so please feel free to reach out if you have more questions on it. And if you ever do want to do a search, you can do that through our systems because you want to see if something's already been invented before. You can look at our systems and you can do that through our website as well. We also have a trademark boot camp. A trademark boot camp similar to a patent, Path to a Patent. It is an 8-part series. We give it once a week. It'll take you from start to finish, really. And so a lot of people actually do, a lot of businesses do file their applications themselves. And so this is a great course for you to take in order for you to go through all of the different steps. We also have a 1-800 number if you do have questions or you get stuck. And then one thing that I'm going to mention is that we do have reduced fees for filing patent applications. We don't on the trademark side, but on the patent side, we do. And so if you are a small business, you meet the income threshold and you do not have more than 5 patent applications where you're listed as an inventor, then you can qualify for this micro entity status. Okay. Now, the one thing I am going to point out is we do have pro bono services. And so we have volunteer attorneys who have volunteered to be able to provide free legal services on both the patent side and actually on the trademark side and copyright side. And so we have at least one pro bono organization per state. In Texas, it is the Texas Accountants and Lawyers for the Arts. They're located out of Austin, but the attorneys are located all throughout the state of Texas. And so if you do want to go down this path, I know especially for patents, it can be an expensive process, but we do have volunteer attorneys that can help support that. We also,
Just repeat the name of that place in Texas.
Texas Accountants and Lawyers for the Arts.
Thank you.
And so their contact information, you can actually find it on our website at uspto.gov. Okay. And so we also have law school clinics. Law school clinics are law students supervised by practicing attorneys who can also help support your patent or your trademark application process. The nice thing about law schools is that they don't have the income threshold like you would for the pro bono clinics. They're there for educational purposes. And so they are really looking to be able to help support their students learn the process. And so in Texas, particularly in the DFW area, we are very fortunate to have 3 law schools close by. Texas A&M School of Law in Fort Worth, SMU Law School in Dallas, as well as Baylor in Waco. All of them have both patent and trademark clinics. We do have one more in Houston, right? In South Texas College of Law, as well as a great resource for you. If you are in the process and you are going to be appealing your case, then there are options for you from a patent standpoint. We do have attorneys that volunteer for that. And then we do have libraries that have librarians that can assist you with your searching. And so in the DFW area, we have 2. We have UT Arlington as well as Dallas Public Library that can help you with searching, see if something's been filed before with our office. Okay, last slide, and then I can get to questions, is follow us on social media. Here's the contact information for that. And then if you do have any other questions, you are more than welcome to reach out to me at our website or at our email here. Okay, I'm going to open it up to questions officially now.
Okay, great. That was such great information. I'm sure we're kind of overload here.
Yeah.
All right, we're going online first. All right, Kimberly, what do you have?
Peggy has a question. She has some copyright music that a co-writer followed with the government. She wrote the music, but he and his wife created the words. However, when they filed the copyright, he added a person's name who had nothing to do with the piece. Can she object to that copyright, or what can she do to get the person's name removed from the copyright?
Okay, that's a great question. And I didn't quite hear the very beginning, but
Yeah,
it sounds like there was a mistaken author that was added to that copyright. Is that right?
Yes.
Okay. That is a great question, and I actually do not know the answer to that because I haven't worked in that area. If if you could do me a favor, whoever asked that question, if you can send me an email at southwest@uspto.gov. And then let me see who I can point you to on that, and then I can get back to you. I don't know the answer to that right now.
Okay, great. All right, she had her hand up the
Okay.
last time.
Yes, ma'am. So I know I came in late, apologize for that, and you might have already answered this, but how long did trademarks last and what qualifications do I need to take to make sure that I can keep my trademark in place?
Okay, that's a great question. So a trademark lasts as long as you are using it in commerce. Okay. And so as long as you are using it in commerce, meaning that you are actually advertising it, you are selling your services, you are actually providing services or goods, right? As long as you are doing that, then your trademark is going to be good until that time period in which you are not using it as well. Now, that's separate than maintaining your trademark registration. After you file with our office, you have to renew your registration. At the first time you'll do that is at the 5-year mark, and then the second time at the 10-year mark, and then every 10 years after that, you'll be renewing with our office. And in that process, you are actually going to have to show evidence that you are using it in interstate commerce, meaning that you are using your mark, selling your goods, marketing it, actually providing services or goods across state lines. You'll have to be able to show that in your registration to prove that you are continuously using it.
Okay, so if I was to get a trademark locally where I am doing business, and then I start to expand to other states, at that time, would I be able to change my trademark from a local or regional to the US Patent Office?
Okay, that's a great question. And so two separate systems, state, we're not really managing the state system, right? So the state of Texas, if they give you or they grant you a trademark, then we're not really looking at them. And so we're not able to, quote, convert it over to a nationwide mark. Most people go ahead and apply these days for nationwide protection, because if you have a web page, right, at a minimum, you're going to be reaching everyone across state lines. And so it's not that difficult to really prove that you are reaching others across state lines. It's a little bit harder to prove that you are continuously using it, right? And that you are in the process of using it. So if you already have a web page, my suggestion is that you go ahead and apply for a mark within our office so that you get the nationwide protection.
Thank you.
Because what you don't want to do, I'm sorry, is apply only in Texas and then someone else starts using it in New Jersey, right? And then now you're fighting the person in New Jersey for the rights of that. So if you already have it covered within the nation, you can stop the person in New Jersey as well.
Okay, thank you.
Great. Okay. Do we have anyone online, Kimberly? Another question?
Oh, yes, we have a lot. I was just about to write a note to the online community that we may not get to all of them, but we will make sure that the questions are sent. From March, what are the rules about using the word copyright in materials you produce versus using the copyright symbol?
Okay, so, and maybe I'm not answering this correctly, but my suggestion is for you to go ahead and put the copyright symbol on all of your work once you get it done, right? And so typically that's the letter C, and then the year, and then I think the name of the owner, right? That's typically on there. You can look online to see what is the recommended things. And so I would put that on every page of material that you own. And you can use copyright at the back, right? It's the same thing, the letter C with the circle or just the copyright at the back of the work. But you could do that as well. A lot of people do that if you have a book, for example, right? And you don't want to print it on every single page. And so you could do that if you have a compilation of that. But generally, especially for slides or things like that, I would put it on every single page, to be honest.
Right,
I
thank
think I missed something in that question, so I want to make sure as I'm also looking in the room. Is it you can't use that copyright symbol unless you've actually received the copyright?
No, you can start using the copyright symbol once the original work is embodied in tangible media. Okay, so once that happens, your copyright exists. It's different than trademarks. So with trademarks, you actually have to register and get it approved with our office before you can use Circle R. But for copyrights, you can go ahead and start using that symbol. Same thing with TM, right? That would probably be a better equivalent. You could start using TM for trademarks, and you don't have to register it with our office and use TM.
Great, thank you. And I know all the websites, if we look, it says at the bottom, copyright every single year.
Yeah.
Okay, do we have any questions? Okay,
Okay, so when you fill out the application online, how long does that process take and what is the application fee?
Okay, for trademarks?
Copyright, trademark and copyright.
Okay, so for trademarks, yes, you can fill out your application online. You have to set up an account with us, and then there's a form that you can fill out online. For trademarks, we just changed our fees. And so I think it used to be about $275 per class, right, of goods or services. And so, and that's the traditional fee. I don't know if that went up a little bit. It might have gone up a little bit. So if you have multiple classes, it'll be 275 times the number of different classes of goods or services that you're going to be providing or applying for. For
Wow.
copyright, you can also apply online. You would just go to the US Copyright Office. There's an application form for it. For copyright, you'll have to submit a sample of your work that you're going to be protecting. Now, it's been a really long time since I've practiced, but it used to be $50 to submit a copyright. And but I don't know anymore what the new fees are, but you should be able to find it online at the uscopyright.gov, and you can see the fee schedule that they have.
And does it take about an hour or?
So for a copyright, the system is kind of clunky, and so it may take you a little bit of time to do it, but copyrights are relatively easy, so it'll probably take you at most a day, I would think. Trademarks are more complicated, and while a lot of people do their own trademark applications, we also do recommend using an attorney because sometimes it can get a little bit complicated as well. Suggestion is to take the class, at a minimum, the 8-part series, and it'll take you from start to finish on the actual trademark application. Trademark applications will take a little bit longer because you'll have to supply a sample of your mark or a specimen as you are using it in business, and so sometimes it just gets a little bit complicated on what you actually have to provide. So it'll take a little bit more time.
okay, great.
Yeah, no worries.
We'll go online and then one last, I saw your hand up, but first we'll go online.
And if I have a registered copyright on my training content, do I need to copyright all of the books that I've written on this intellectual property?
So yes. So a copyright is only good for whichever thing that you have registered for a copyright. And so if you have more than one book, you'll need to register for more than one copyright to get protected for that.
Great, thank you.
This kind of goes hand in hand with that. If you publish a book, does that, do you also have to submit for it to be copyrighted, or is that kind of part of the process? How does that work with like just publishing a book?
If you publish and you wrote the book, assuming, right? Okay. Yeah.
The hypothetical book.
Right. Yeah, so if you wrote a book and you've published it, then it is already protected by copyright. If what most people do is then they will subsequently register that book with the Copyright Office so that you get the additional protection and some of the additional benefits that I had mentioned.
How do you tell that somebody's copyrighted work is registered copyrighted as opposed to just inherently copyrighted?
The Copyright Office, okay, so the Copyright Office has a database that you can search. It used to be really bad, but I don't know if it's gotten better. I think it has because they've done a lot of work on their IT systems. So you should be able to do a search on the copyright register to see if something is copyrighted.
Okay, great. Such great information. Thank you so much. We do have a little goodie for you. Thank you so much. All right, so let's see what we have coming up, and you'll be around for a few minutes?
Yeah.
Okay, perfect. So if there's anything else then, Lourdes, what do we have?
So the next event we have, because it's the holidays, is our WomenRISE in January. So we will see you guys hopefully all in January, where we will have Kelly Mumphrey turning resilience, talking about resilience in action, turning setbacks into strengths. So Kelly will speak to her own entrepreneurial journey. And she's a veteran, a mother, and the founder of Milk Space. And she will share with us how setbacks can become setups for stronger strategies. So that is what we have coming up next. We hope that you all enjoy a wonderful holiday. Hope we'll be around a little bit longer. Please feel free to network with one another. That's really the point of bringing us together. Same online. Kimberly, you are on. Will be our host going forward. And the same to you all. Happy holidays to everyone, and thank you for being with us today. Kimberly, take it over and virtual.
Feel like she should say to you, Kimberly. Anyway.
It's like Vanna White.
Yeah. Hi, everyone.